This is Chapter 15, Part 2, lecture video, Chapter 15, Part 2. Go to page 466 of the textbook. Second paragraph. A 1990 Supreme Court case held that Miranda warnings are not required when an inmate is questioned by an undercover police officer. Voluntary statements made in this type of situation are admissible because none of the coercive elements of police interrogation are present when the inmate does not know he or she is being questioned by law enforcement personnel. Miranda warnings may even be required prior to questioning by non-police personnel. The need for the warnings prior to a polygraph examination conducted at the request of the police is fairly obvious. Now, also crime lab personnel. If you are a forensic tech student, you know that you're told you are not allowed to ask a suspect questions because you could be violating their Miranda rights and the case could be thrown out. That is not your job. So you're not allowed to be asking questions about the crime. However, next paragraph, volunteered statements are admissible even though Miranda warnings were not given. They are also admissible if a suspect who refused to talk or request an attorney later comes forward and starts volunteering information. Then that's okay. But any detailed questioning that follows the volunteer information is considered interrogation. So if they volunteer information, but then you start questioning, then you could run into Miranda problems. They can be asked questions about their name, address, place of birth without a warning for booking purposes. One of the things, too, when someone's arrested and they're going to be placed in the jail, they may be asked, have you ever tried to kill yourself? And that might just be for their own protection for the jail setting as to where they'll be placed. And that doesn't have to do with Miranda either. Let's look at slide 19, special cases. Juveniles, it depends on the age and appreciation of the rights. Under age 7, there's no possible waiver. Generally, there's parental waiver that's needed. Mentally handicapped, mere low intelligence does not prevent someone from waiving Miranda, but they must be severely mentally retarded before that they're not able to waive it. Intoxicated, a waiver is allowed unless they're extremely impaired. So there's some discretionary issues there. Slide 20, when is Miranda required? Custodial interrogation, if the suspect is formally under arrest, if the suspect is no longer free to leave, it does not cover traffic stops. Why the suspect is in custody does not matter. It applies only to questioning by the government, not by private parties. Page 468. Look at under Waiver of Miranda Rights, third paragraph. Intelligent, as used in this context, means that the person had the basic intelligence necessary to understand his or her rights. This may be an issue if a young juvenile is involved. A couple sentences down. Age and emotional immaturity might be looked at, or extremely intoxicated. No coercion may be used to obtain a confession. That's all the way at the bottom. Page 469, third paragraph. Physical force cannot be used to obtain a confession. Deprivation of food or sleep for long periods is not allowed. Neither are false promises of leniency, such as offers to drop charges or assurances that the suspect will get immunity or a light sentence if he or she confesses. Not allowed. Skip a paragraph. The police do not have to tell the suspect all the crimes being investigated, nor do they have to inform him or her that someone has arranged for an attorney to come to the jail. That's not required. Slide 21. Orozco versus Texas. Orozco was questioned by officers at 4 a.m. in his bedroom about a homicide. He had not yet been formally charged with murder. If, as was the case, Orozco was not free to leave as he was in custody. Once in custody, your right against self-incrimination is triggered. The confession was excluded. Oh, okay, so Orozco was not free to leave. He was in custody. So they couldn't use that because they violated Miranda. Slide 23. When is Miranda not required? Voluntary interview or statements. Booking. General questions about your name, your birth date, your address. Have you ever tried to kill yourself? Those are general questions asked during booking. Public safety exceptions. In dire emergencies, there's exceptions. Slide 24. New York versus Quarles. A rape victim identified Quarles as the perpetrator. The police frisked Quarles and found an empty gun holster. Concerned about the loose weapon, he asked its location without giving Corliss the Miranda rights. The gun was still admissible when found under the public safety exception. Slide 26, waiver of Miranda. Any waiver must be knowing, intelligent, and voluntary. Intelligent, basic level of intelligence is necessary to understand the rights. Voluntary, no physical coercion, applies only to police and their agents, no third degree, look at totality of circumstances. We already talked about that. Slide 27, continuing of questioning. Suspects need not state they wish to continue with questioning. No explicit waiver of Miranda is required. Silence will generally allow questioning to continue if they're being questioned already. Slide 28, sequential interrogations, so one interrogation after another. The police have a second interrogation, often based on information from the first interrogation. So they interrogate, they find out information, they want to continue and ask questions that they discovered more information. If the first was improper, so if they questioned and violated Miranda, then they can't use what they learned for a second interrogation. If the first was voluntary, but not Mirandized, the second may or may not trigger the fruit of the poisonous tree. So it depends on the validity of the first interrogation. And if they're now going to start a second interrogation, they may or may not need to Mirandize. Slide 29, sequential interrogations continued. Original interrogation may be admissible to impeach the suspect, but they can have a second interrogation without a new Miranda if given in the first interrogation. But a passage of time, if too much time took place, there might be a need for a new Mirandized warning. So that would probably be argued in court quite a bit there. Page 472 talks about this. If the first confession at the top was involuntary, all subsequent confessions are inadmissible. If the first confession was voluntary but in violation of Miranda, a subsequent confession may be admissible if a new set of properly administered Miranda warnings were given and the suspect waived his or her rights. It really comes down to each case, looking at it. About halfway down, using the first confession as the primary focus of the second interrogation session would likely trigger the fruit of the poisonous tree doctrine. A voluntary confession obtained several days after the suspect was released from custody will more than likely be admissible if enough time had passed. Let's go ahead and, okay, slide 30, invocation of rights. If a suspect invokes the right to remain silent, that means they say, I want to remain silent. The interrogation must end. But detectives can try later. If suspect invokes the right to attorney in custody, all questioning stops. No new questioning until the attorney is present. You don't need to stop if the request is unclear. And it applies even to questions about different crimes by a different officer without knowledge of the request. Let's look at page 473. The suspect invoked the right to remain silent. The police must stop interrogation immediately if the suspect invokes the right to remain silent. This rule applies whether the suspect invoked the right to remain silent at the time the Miranda warnings were initially given or asserted them after custodial interrogation was in progress. This does not mean, however, that the police may never try to resume questioning, but the police may not badger the suspect with frequent attempts to get the suspect to talk. But after a reasonable amount of time, they may ask the suspect if he or she would like to continue the interrogation. That's okay. Slide 31. Edwards versus Arizona. Edwards was charged with robbery, burglary, homicide. He initially cooperated, but eventually requested to speak to an attorney. The next day, the police restarted interrogations without an attorney. The Supreme Court ruled the interrogation was inadmissible. Slide 32. Tompkins was arrested for a homicide. He was informed of his right to remain silent, and he did remain silent. However, did not say he was remaining silent or ask for an attorney. Police continued interrogation and got a confession. The Supreme Court allowed that confession. Slide 33, special situations, illegal arrest. Miranda will not cure illegal arrests. Exclusionary rule, impeachment. If voluntary, then a non-Mirandized statement can be used for impeachment. And post-arraignment or release. The police may not question post-arraignment or release. Page 477. If juveniles ask to speak to the parents, the questioning must stop. That's the same thing as like wanting to speak to an attorney. And page 478, impeachment. Anything that they say can be used to impeach them. Coerced statements are never admissible in court. but voluntary statements may be used in interrogation to impeach even though there was a Miranda violation. Whew, that's the end of Chapter 15.